Hi, I'm Ryan. And what's the deal with Supreme Court legitimacy?
So, if the court is, I'm not talking about any particular decision or even any particular series of decisions, but if over time the court loses all connection with the public and with public sentiment, that's a dangerous thing for a democracy. We have a court that does important things, and if that connection is lost.
I don't understand the connection between opinions that people disagree with and the legitimacy of the court.
That's a dangerous thing for the democratic system as a whole.
When political scientists talk about Supreme Court legitimacy, also called institutional legitimacy or diffuse support, they mean the public's deep-seated psychological conviction that the court is appropriate, proper, and just. It's not just about whether you like today's decision, it's about whether you feel an obligation to obey tomorrow's ruling even when you hate it. This belief leads people to defer to the court's judgments voluntarily, not because they fear punishment or because they expect some reward. In short, legitimacy is the institution's reservoir of goodwill, a political capital that the court draws from to implement controversial decisions and navigate cases. As James Gibson put it, legitimacy is for the losers. Its true value appears when the court rules against you and you still accept its authority. Legitimacy rests on several foundations. People tend to connect their trust in the court to democratic values and procedural justice, especially when they perceive that the court behaves impartially and fairly. They like to think that courts are different, neutral, fact-focused, above partisan brawls. Symbols of the court, for example, reinforce that belief. Robes, marble columns, Latin phrases, and solemn ceremonies aren't just window dressing. They cue citizens to view the court as a legal rather than a political body, and trigger pro-legitimacy biases in how we process information. The perception that justices decide cases on principle rather than party is central. When the court looks like just another political actor, legitimacy suffers.
The Constitution is the supreme law of the land, and the Supreme Court is its voice, echoing the constitutional faith spelled out by the Founding Fathers in the summer of 1787. As the guardian of the Bill of Rights, at times the court finds itself riding waves of controversy.
For decades, scholars believed legitimacy was impressively stable, rooted in core democratic values and resistant to momentary anger over specific rulings. Recent scholarship, along with recent actions by the Supreme Court, complicate that story. We now see more movement in legitimacy attitudes than once thought possible, and those shifts track political cues and performance evaluations more closely than the old models suggested. Principally, the Dobbs decision overturning Roe v. Wade put a visible dent in institutional support and polarized assessment by party in ways we haven't really seen before. Aggregate stability in the public's view of the court as legitimate might still hold over long spans, but individuals clearly recalibrate their judgments in systematic ways. They respond and mentally punish the court based on their perceptions of these baseless or politically motivated rulings. What then shapes this legitimacy other than the court's rulings? Elite rhetoric and partisan cues also matter. Attacks or endorsements from presidents, presidential candidates, and other salient figures can alter affect towards the court. That's affect with an A, often through emotional rather than ideological cueing. Partisan attachments and social identity can become kryptonite to the court's traditional positivity bias. If you adore a party leader who denounces the court, those warm feelings can overpower your prior respect or judicial authority. This actually happened a lot under the Warren Court in the civil rights movement and beyond, where more conservative entities lambasted the court for being too activist in their rulings. Lesser-known elites can move the needle too, so long as their partisan team is obvious. At the same time, ideological congruence plays a role. People who think the court is ideologically close to them tend to rate its legitimacy higher, and those who see it as distant downgrade their diffuse support. When the court looks politicized, when confirmation hearings devolve into partisan warfare, or when justices' public speeches sound strategic rather than judicial, legitimacy inevitably erodes. Justices know this, and often stress that they're neutral arbiters, merely applying law, not partisans dispensing favors. Specific support and diffuse support were once treated as distinct. You could hate a decision, but still cherish the court. It was, after all, a common phrase to say that to know the court is to love the court. Yet newer research shows those lines can blur. Sustained disappointment with outputs or a string of decisions viewed as hostile to your personal beliefs can feed back into institutional judgments. Some scholars even introduce the idea of Supreme Court fatalism, a pessimism that the court will always win political battles, and that its role in democracy is fixed and negative. That fatalism depresses perceived legitimacy as well. Appointment politics compound the dangers for fatalism. The speed of Justice Ruth Bader Ginsburg's replacement, the blockade of Merrick Garland, and the bruising confrontations of Neil Gorsuch and Brett Kavanaugh made many Democrats conclude that the institution had become a partisan prize, not a neutral tribunal. The democracy gap, the idea that justices can be appointed by presidents who lost the popular vote and confirmed by senators who represent fewer voters, raises new worries about whether the court can claim democratic legitimacy at all. Whether that gap actually drains legitimacy is contested, especially if decisions align with dominant political elites, but the perception of a mismatch between popular democracy and judicial power is real. Additionally, descriptive representation matters too. By that, I mean how much the bench looks like America. Research finds that identity on the bench can shape perceived legitimacy. African Americans, for example, often rate the court as less legitimate, given the history of legal symbolism and outcomes that harmed their communities. I'm looking at you, Dred Scott, and Plessy v. Ferguson, and Korematsu v. U.S., and Baki, and Sweat v. Painter, and... Measuring legitimacy requires more than a single approve or disapprove poll item. Scholars typically deploy batteries of survey questions that tap institutional loyalty. Would you support abolishing the court? Would you strip its jurisdiction? Reform it drastically? These items gauge whether citizens want fundamental changes, or whether they are content to keep the court intact, even as they criticize its decisions. Trust, confidence, performance satisfaction, and approval all matter, but they're not the same as diffuse support. Recently, researchers have begun to ask about concrete reforms directly to capture openness to structural change. Court expansion, term limits, jurisdiction stripping, as another window into legitimacy attitudes.
Hi, I'm Saul Goodman. Did you know that you have rights? The Constitution says you do, and so do I. I believe that until proven guilty, every man, woman, and child in this country is innocent. And that's why I fight for you, Albuquerque!
To understand why legitimacy looms so large in political science, you have to start with the court's constitutional design. The Constitution vests the judicial power in one Supreme Court, and whatever inferior courts Congress creates. Judges serve during good behavior with salaries that can't be diminished because, as Hamilton says, control over a judge's subsistence is control over his will. Permanency and pay security are supposed to foster independence for the judiciary. The court's jurisdiction covers cases arising under the Constitution, federal law, and treaties, disputes among states, diversity cases, admiralty, and more. It exercises original jurisdiction in a narrow band of cases, and appellate jurisdiction when such exceptions and under such regulations as the Congress shall make. That last phrase gives Congress real leverage over the docket. Crucially, the court has neither the sword nor the purse. It relies on judgment and on the executive arm to enforce their rulings. Its authority rests on public and political actors' willingness to accept its interpretations as binding. Judicial review, striking down laws that violate the Constitution as void, positions the court as an intermediary between the people and their representatives, upholding the fundamental law against legislative, momentary passions. That power wasn't operationalized until the case Marbury v. Madison, decided years after the Federalist Papers laid the theoretical groundwork, but once claimed, it anchored the court's institutional role. This structural weakness is exactly why legitimacy is essential. The court can't deploy troops or cut funding. Its power is normative and psychological. If the public and elected officials don't buy its right, moral and legal to make decisions, the black robes are just fabric. Scholars obsess over legitimacy because it's the non-coercive foundation of judicial influence. It allows the court to withstand the counter-majoritarian dilemma, to tell a majority no when the Constitution says so, and still expect compliance with their rulings. Without the reservoir of goodwill, the court might cave to public opinion or risk open defiance from another branch. In today's climate, partisan sorting of legitimacy is new and worrisome. Chief Justice John Roberts has warned that the partisan hostility that people see in the political branches will affect the nonpartisan activity of the judicial branch. Recent evidence suggests legitimacy has fallen overall and is now closely tied to partisanship, especially among Democrats who have grown more cynical and more fatalistic.
With all due deference to separation of powers, last week the Supreme Court reversed a century of law that I believe will open the floodgates for special interests, including foreign corporations, to spend without limit in our elections.
The Constitution tried to protect legitimacy by insulating judges, life-tenured, fixed salaries, and the image of impartial experts who consult nothing but the Constitution and its laws. The Federalist Papers note that the judiciary is the least dangerous branch because it commands neither money nor arms, which should reassure citizens that it can't tyrannize them. Independence, impartiality, and expertise are supposed to earn trust, but an independent court is only as strong as the willingness of the governed to accept judgment in place of force. As legitimacy drops, the prospect of defiance, reform, or circumvention rises. That's why political scientists pore over survey batteries, elite rhetoric, case salience, and appointment politics. The court's compliance currency is volatility prone, and the stakes, constitutional limits, minority rights, and the rule of law are high.
Be advised, you are currently engaged in illegal demonstrations.
After 3 warnings from Capitol Police, more than a dozen House lawmakers demanding federal abortion rights were arrested outside the Supreme Court Tuesday.
We will not stop fighting.
So what's the deal with court legitimacy? It's the difference between an authoritative constitutional umpire and a 9-member super legislature the public and even government officials feel free to ignore. It allows the justices to hand down unpopular rulings without tanks or paychecks to back them up. It's for the losers, the ones whose policy preferences just lost, and it's tested every time the court wins a case the public hates, or even the president. Whether that reservoir remains deep enough in an era after Dobbs, an era of hyper-partisan confirmations, and an era of democracy gap debates will shape not only the court's future, but the durability of constitutional governance itself. As always, there's a list of references cited in this video in the description below. In the next one, we're going to dive into an interesting concept relating to human rights. Until next time.